Next matter is case 23-1931 FY. This is People of State of Michigan versus Lydia Nance. Says for the record, please.
Thank you, sir. Pulled on behalf of people.
Donna Harrison Munson on behalf of Ms. Nance.
Okay. What are we doing today, Ms. Holda?
Thank you, Your Honor. Last week, defense counsel appeared via Zoom, indicated the intention of the defendant to waive 21 days. I believe that's what is going to be happening today. Based on that assessment from last week, we called off witnesses and will not object to a waiver of the 21 days.
Mr. Munson, so why would we be waiting the 21 days?
Yes, we will do that, Your Honor. We're asking for a reduction in bond also because I have not had.
Let's do one thing at a time. Right. Why are we, please stand when you're talking to me.
I'm sorry.
Why would we be waiving the 21 days?
Because we don't want to, we have a lot of information that we have to go through. We haven't had an opportunity to go through all of the information.
So you just are in receipt of the discovery? Do you think you have all of it?
We think we do, but we're not 100% sure because I haven't been able to look at all of it. It's quite a bit.
Okay. Ms. Nance.
Yes.
Let me get you to come over to the podium.
Want me there too, Your Honor?
Sure, you can come up over. Ms. Nance, do you understand what's happening? Tell me what you think is happening.
Coming forward.
That's all you understand? Let me explain to you. Our system of justice divides crimes into two categories: felonies and misdemeanors. And felonies are, of course, considered to be more significant than misdemeanors. So we have a rule that says basically that people that are charged with serious offenses shouldn't have to have them just sort of hanging over their head for an extended period of time. So we have a rule that says that within 21 days of the charges being read to you, you have a right to have a hearing. That hearing is called a preliminary examination, and the purpose of that hearing is to put the prosecutor through the proofs. She has to show that there's probable cause to believe that a felony occurred and probable cause to believe that you're the person that committed the felony. If she couldn't do that, then the charges against you could potentially be dismissed. What I understand from your lawyer is that he doesn't believe that you need to have that hearing within 21 days. He wants to have that hearing at a later date because he's saying that there's a lot of information for him to still become familiar with in order to properly represent, which means that that's going to take more time for the case to go forward. Which also means that it would not happen within 21 days. So it's important enough that I wanted to talk to you to make sure you fully understand what's happening. Now that I've explained it to you, you feel like you have a better understanding of what's going on.
Yes, Your Honor.
Do you have any questions or concerns about what's going on? So you understand that there is a possibility that you could be in jail a longer period of time waiting to have that hearing because of the delay that this is going to cause. So I think that your lawyer also wants to ask me about something that has to do with your bond. But I may not actually grant his request about that. I'm sitting in jail for a long period of time waiting for you.
Yes, Your Honor.
So let me listen to what Mr. Munson has to say about his request to change your bond.
Your Honor, we've had an opportunity to talk about bond, and currently my client has a $200,000 10% bond, and she has people who are willing to help her because she's a good person. She's never been in trouble before, and so we're asking the court to reduce the bond to 100,000 because at 100,000, we believe that she can get out quicker, and we can discuss her matter, and she'll be able to get a bond.
Okay.
Thank you, Your Honor. This good person, per the defense counsel, shot and killed a 17-year-old minor for no reason other than to shoot and kill her. There has been zero change in circumstances from this defendant from the time that she was arraigned and provided that bond. We would object to any reduction in the bond. We don't believe that there has been any change or anything provided to the court today to even request a reduction. So we would ask that it remain as is.
Yeah, she's presumed to be innocent of the charge, of course.
Because of self-defense, Your Honor. It's
It doesn't matter if it's self-defense or any defense or whatever. Someone by the law to be innocent of the charge.
that's correct. Yeah. And we
Did
just,
you want to respond to Ms. Pola?
I'm sorry.
Did you want to respond to Ms. Pola?
Yeah, she basically said she shot a 17-year-old. It's true that that person was shot, but there's a reason why that person was shot. Yeah, well, the deal is, I believe that her bond, if her bond was reduced to 100,000, she has the resources to be able to get out of jail, and then she'll be in a position to discuss her case with me whenever she wants to, instead of going forward now. That's what we ask.
Who made considerations around actually three the charge? The nature of the charges is that open murder. She doesn't have to get a bond at all. She can be denied bond. So $200,000 10% bond could actually be considered to be generous under the terms of the rules. Secondly, what I'm supposed to look at is the likelihood that she is going to return to court to face the charges. Third, whether the community because of the likelihood of there being some disruptive behavior if you were released.
That's correct.
But none of those things actually side in favor of your client.
Except she's born and raised in the city. She's lived here all of her life. She's no flight risk because she has a family to go to at her house where she lives.
Definitely a flight risk because before she was charged with open murder, she's charged with open murder and she's sat in jail for a number of days.
Mhm.
I'm not going to change your bond at this point. I'm not going to increase it. She could be held without bond.
Yeah, we understand.
Just based on the charge. So bond will be continued on its current terms. Are we still looking at February 6th as the date for this one as well? What's in February 6th?
2/6.
9:30.
Thank you, Your Honor.
Okay. Nancy, do you have any questions?
No, Your Honor.
Sure. It won't be too long before we'll see you back in court. But always understand that you can raise questions or concerns with me. Try to be addressed. Don't want you to be said.
Yes, sir.
Thank you, Your Honor.
All right. You need more time to speak with her, Ms. Johnson. We can arrange that.
Yes, please.
Can you arrange to
Yes, sir.
have them speak with her? Yes. Okay.